Ready, start. It is trite law that application of judicial mind being necessary to determine whether a case has been made out by the prosecution for proceeding with trial, and it would not be necessary to dwell into the pros and cons of the matter by examining the defense of the accused when an application for discharge is filed. Full stop. At that stage, the trial judge has to merely examine the evidence placed by the prosecution in order to determine whether or not the grounds are sufficient to proceed against the accused on basis of charge sheet material. Full stop. The nature of the evidence recorded or collected by the investigating agency or the documents produced in which prima facie it reveals that there are suspicious circumstances against the accused, so as to frame a charge would suffice, and such material would be taken into account for the purposes of framing the charge. Full stop. If there is no sufficient ground for proceeding against the accused, necessarily, the accused would be discharged, but if the court is of the opinion, after such consideration of the material, there are grounds for presuming that accused has committed the offense which is triable, then necessarily charge has to be framed. Full stop. At the time of framing of the charge and taking cognizance, the accused has no right to produce any material and call upon the court to examine the same. Full stop. No provision in the code grants any right to the accused to file any material or document at the stage of framing of charge. Full stop. The trial court has to apply its judicial mind to the facts of the case as may be necessary to determine whether a case has been made out by the prosecution for trial on the basis of charge sheet material only. Full stop. If the accused is able to demonstrate from the charge sheet material at the stage of framing the charge, which might drastically affect the very sustainability of the case, it is unfair to suggest that such material should not be considered or ignored by the court at that stage. Full stop. The main intention of granting a chance to the accused of making submissions as envisaged under section 227 of the CRPC is to assist the court to determine whether it is required to proceed to conduct the trial. Full stop. Nothing in the code limits the ambit of such hearing, to oral hearing and oral arguments only, and therefore, the trial court can consider the material produced by the accused before the IO. Full stop. It is settled principle of law that at the stage of considering an application for discharge, the court must proceed on an assumption that the material which has been brought on record by the prosecution is true and evaluate said material in order to determine whether the facts emerging from the material taken on its face value, disclose the existence of the ingredients necessary of the offense alleged. Full stop. The defense of the accused is not to be looked into at the stage when the accused seeks to be discharged. Full stop. The expression double inverted comma the record of the case double inverted comma close used in section 227 CRPC is to be understood as the documents and articles, if any, produced by the prosecution. Full stop. The code does not give any right to the accused to produce any document at the stage of framing of the charge. Full stop. The submission of the accused is to be confined to the material produced by the investigating agency. Full stop. The primary consideration at the stage of framing of charge is the test of existence of a prima facie case, and at this stage, the probative value of materials on record need not be gone into. Full stop. This court, by referring to its earlier decisions in the state of Maharashtra versus Somnath Thapa and the state of MP versus Mohanlal Soni has held the nature of evaluation to be made by the court at the stage of framing of the charge is to test the existence of prima facie case, full stop. It is also held at the stage of framing of charge, the court has to form a presumptive opinion to the existence of factual ingredients constituting the offense alleged, and it is not expected to go deep into probative value of the material on record and to check whether the material on record would certainly lead to conviction at the conclusion of trial. Full stop. On a careful conspectus of the legal spectrum, juxtaposed with our view on the facts and merits expressed herein before, we are satisfied that there is no suspicion, much less strong or grave suspicion that the appellants are guilty of the offense alleged. Full stop. It would be unjustified to make the appellants face a full-fledged criminal trial in this backdrop. Full stop. In an appeal dealing with the refusal of the High Court to quash an FIR under Section 482, CRPC, albeit, this court, while setting aside the judgment impugned therein and quashing that FIR, took the view that single inverted the appellants are to be protected against vexatious and unwarranted criminal prosecution, and from unnecessarily being put through the rigors of an eventual trial, full stop, single inverted close, full stop.